2021 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the Dfc courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Khalifa bin Huwaidan al-Kitbi Advocates and Legal Consultants. Lead counsel is PV Danish. The defendant is represented by Tamimi & Company. Lead counsel is Mr. Matthew Watson. Thank you.
Thank you. It's your application, Mr. Watson.
Yes, I'm grateful, Your Honour. Maybe if I could just ask my learned friend to mute himself during my submission so that we don't get the feedback.
Yeah, sure. I won't be bothering you at all. Don't worry.
You'd be grateful. Your Honour, you should have a case lines bundle, and you should have received a skeleton argument from me and from Mr. Saroj at the claimant's law firm. This is an application for immediate judgment by the defendant. The claimant is His Excellency Hamad Al Khaili. I'll just refer to him as the claimant. As you will have seen, his claim is for breach of a client agreement between him and the defendant. Unless you want me to, Your Honour, I'm not going to spend any time on the principles applicable for applications for immediate judgment. We're all familiar with those. I'm going to deal with my submissions in three parts. Firstly, what is in issue, and importantly, what is not in issue. In my submission, there's only really a narrow factual issue that centres around what happened on the 3rd of July 2019. There are a lot of other points that have been raised by the claimants, but in my submission, they all sort of fall away. And the only issue that Your Honour needs to decide is that narrow factual question. Once I've dealt with that, I'm going to make some broad submissions about the evidence that's before Your Honour. And then thirdly, I'm going to show Your Honour why the claimant has no real prospect of success at all on that key issue. So I'm going to start with identifying...
I've read the papers, Mr. Watson, so you can take it that I'm familiar with the background and so on and so forth.
I'm grateful, Your Honour. To identify sort of what is in dispute on the pleadings, the essential facts are not in dispute, in the sense that in June 2019, the claimant transferred 175 million dirhams to his account with BNP Swiss. In July, so about a month later, he asked for that sum to be transferred back, but not all of that sum was transferred back, only about 174 million odd, and there was a difference of about 600,000 dirham. There's no dispute about what caused that difference. BNP Swiss had converted the dirhams into US dollars. It had bought two Islamic products, a 3-year Islamic floating profit note and a callable range accrual note. It then sold those two products pretty quickly. That led to a capital loss because they were sold before maturity. It converted the US dollars back into dirham, and there were also some modest losses arising by the currency conversions. As you'll have seen, the claimant's case is that the defendant's liable for those losses. Obviously, the defendant isn't the bank. The defendant's role is to transmit instructions from the client to the bank. It's accepted that the defendant does not have a discretionary mandate. So I accept that the defendant can't decide for itself what investments are to be placed. It has to act on instructions from the client. The claimant says that there was no instruction. That's his case. The defence is simple. The claimant authorised those transactions. The case is put in two ways. Firstly, the claimant himself actually authorised the transactions, and he did so in a meeting on the 3rd of July 2019, so that the instruction that BNP Dfc transmitted was transmitted with the claimant's actual authority. And the second limb of the defence, if I can put it like that, is that the defendant was entitled to transmit Mr. Jafar's instructions. And you will have seen, Your Honour, he's the individual who runs the claimant's private office. The claimant signed a mandate giving Mr. Jafar authority to give instructions on his account. And over the telephone on the 3rd of July 2019, Mr. Jafar gave those instructions. Now, in terms of the claimant's response to this, I've been able to identify 5 points. Firstly, they say, well, the claimant just didn't authorise the investments. That's an issue of fact. and I'll address that in due course. Second, it said the claimant didn't give any written instructions. Now, the relevance of this is not explained because no case has been pleaded to the effect that the bank or the defendant could only act on written instructions, that there is some restraint on the bank contractual, that it can only act on written instructions. Even if such a case were to be advanced, it can be dispensed with easily. The client agreement permits all instructions. The mandate that Mr. Jafal signed that was signed to permit Mr. Jafal to give instructions permitted all instructions, as did the bank's original opening terms. So any issue about written instructions is, in my submission, irrelevant. It doesn't defeat the defence. The third point that's taken against me is it said that it was pleaded that no copy of the mandate had been provided, and so it was denied that Mr. Jafal was appointed to act as an agent. That was factually wrong. They had a copy of the mandate in pre-action correspondence, but in any case, that's not a defence. The mandate has been produced. There is no case pleaded that on the terms of the mandate, Mr. Jafal's authority isn't wide enough to give the instruction that he gave. They just deny that he gave it. So in my submission, there's no point actually arises there. The next point that's pleaded is that in relation to the mandate that authorised the bank to accept instructions from the defendant, it said the defendant failed to act in the claimant's best interests. That's what's pleaded in the reply. But there's no obligation in the mandate as such to act in the claimant's best interests. The defendant's duty is just to pass on instructions. So I mean, if all that's meant by that is to say, well, the defendant has to act on the client's instructions, then of course I agree, subject to the issue about what counts as an instruction from the client. And the final point that's taken is that Mr. Jafal did not give an instruction to buy the Islamic notes. It's not very clear from the reply whether this is actually pleaded, but the point was taken in the response to the immediate judgment application. I'm not going to take a pleading point over this. So having gone through everything in my submission, this entire dispute just boils down to two factual questions, and they both involve what happened on the 3rd of July 2019. Did the claimant approve the investments in the Islamic notes? That's the first question. And if he didn't, did Mr. Jafal give instructions for the Islamic notes? Because even if the claimant didn't give an instruction, Mr. Jafal was entitled to give instructions and the bank could just rely on his instructions. And everything else is irrelevant, save insofar as it sheds forensic light in my submission on those two questions. With that, I just want to make clear two matters that are not in issue. You'll have seen reference to the purchase of Cooke. That's a form of Islamic bond. On the 3rd of July 2019, there was an order placed for the purchase of Sukuk's, but they were cancelled before any were purchased, so it doesn't cause any loss. I don't think that's disputed. There's some complaints in my learned friend's skeleton about the process for the purchase of Sukuk's, but that's all irrelevant. Again, save insofar as it sheds forensic light on the instruction in relation to the Islamic notes. So Your Honour can probably put most of the issues to do with the Sukuk's to one side, really, because they just don't take the claimant anywhere. The second point, which I just want to highlight as something that's not being an issue, is a new point that was developed in the skeleton argument, which was breach of the Dfsa's guidance. I don't know whether it's actually said that the rule was breached, but breach of Dfsa guidance. My instructors list has tried to identify the authority, but weren't able to. It was a document was finally provided about an hour ago. It's been added to Your Honour's bundle. It seems to be part of the anti-money laundering guidance. From what my solicitors have been able to discover, it doesn't even look like what's been provided is the right version that was in force at the time. But be that as it may, I think what's said is that because the account was dormant at one stage and then monies were paid into it, there was some duty to undertake, know your client, and confirm the renewal of mandate that authorised Mr. Jafal, and it's alleged as well that the claimant wasn't categorised as a professional investor. He should have been categorised as, I assume, a retail investor, or that poor advice was given. The simple answer to that is absolutely none of it is pleaded. So it's not open to the claimant to take any of those points. A case that there's been a breach of the Difsa rules would be a totally different case from the breach of contract claim that's pleaded. As a result, I haven't led any evidence on whether KYC checks were undertaken, because that's not the case that's been advanced to date. Indeed, there's no evidence at all from either side about any of that. So it's hard to see how it can really form any part of the claimant's case. But even if the defendant didn't carry out any know your client, my question rhetorically is, so what? There's no suggestion that the defendant was dealing with someone who was pretending to be Mr. Jafal or the claimant. So there's just no causal relevance to any of this. And all the other points are bad as well. The idea that Mr. Al Khaili is not a highly sophisticated client seems to me to be absurd. And whatever the issue was in relation to the advice about the Sukkooks, none were purchased. So I'm not going to say any more about that. I'll wait to see if my learned friend develops it in his submissions. But the simple answer is none of it's pleaded, and so it shouldn't trouble Your Honour. Before I dive into the underlying documents that I want to take Your Honour to, just two short points, and I'm sure Your Honour will have these in mind. The first is the absence of any evidence from the claimant. So the defendant has served a detailed statement from Miss Peugeot. She was the relationship manager. She was involved with events from beginning to end. Your Honour's no doubt read that. The claimant has served no evidence. No witness statement from him. No witness statement from Mr. Jafal. And it's not the case that there are going to be witness statements coming, because the deadline for the service of trial statements has already elapsed. So they're in breach of the rules. They're not entitled to put in any evidence at this stage. The position is even worse than that, because there's not a single document in these proceedings where either the claimant or Mr. Jafal has signed a statement of truth. So not even the pleadings. If my learned friend was going to say, well, at least maybe you can rely on that as some limited evidence, he can't even do that, because the statement of truth is just signed by the lawyers. So there's no evidence whatsoever from either of them. And two things flow from that. Firstly, that's a reason in itself why this claim just has no prospect of success, because at the very minimum, the claimant needs to say in evidence, I did not authorise those investments. It's not sufficient for his lawyers just to assert it on instructions. There's a bare threshold level of evidence to get this case off the ground. And the problem you see is at trial, the claimant's lawyers are going to have nothing with which to support that limb of their case. The second problem is that, or the second consequence, I should say, is that Your Honour is in essentially the same position as the trial judge. You have all of the evidence. Ms. Peugeot's evidence is unchallenged. Insofar as it's necessary, her written evidence can be compared against the documents. Your Honour can do that as well as the trial judge. So in my submission, any sort of usual caution that might be applied on an application for summary judgment just falls away. The second evidential point that I just want to draw Your Honour's attention to is about the recorded conversations that Ms. Peugeot had with Mr. Jafal and the transcripts. Your Honour will have seen that the defendant served English transcripts with Ms. Peugeot's evidence. There's a point taken in my learned friend's skeleton that those are not, quote, legal translations. I don't understand that submission, because there's no rule about how translations are to be made. There's a reference to Rule 35.37 of the RDC, but that's a rule dealing with how translations are included in a trial bundle. It's not a substantive rule. Ms. Peugeot explains in her evidence how the transcripts were prepared, and in my submission, that is adequate. The claimant didn't ask for any of the recordings in document production. He only asked for them shortly before this hearing. They were provided. With the skeleton, the claimant has served some transcripts of his own, and I just make 2 points about them. I'm going to show some of them to Your Honour in a moment. Firstly, they have no evidential status, and so Your Honour should afford them no weight. That's because they were served late. There's no application for permission to adduce late evidence, and if there were such an application, it'd be resisted. And these are also just documents floating in the ether. They're obviously not contemporaneous documents. The transcripts were created only a few days ago. There's no evidence about how they were created. They appear to have been produced by a local translation firm, but what there isn't evidence about is whether the translators listened to the audio recordings or made a translation of an Arabic transcript that they were provided with. And if that's the explanation, well, where did that transcript come from? And if they want to rely on material like that, they needed to have put in evidence, but they haven't. The second point.
There's one basic point, isn't there, Mr. Watson? Perhaps I'm anticipating you already. Whenever one has a translation issue of any kind, one looks at the contemporary documents and sees whether or not the translations accord with the documents that immediately preceded and followed it.
Well, Your Honour, you are prefiguring where I'm going to go, because my second point was going to be.
Didn't mean to stop you.
The second point is twofold. They're obviously poor translations, and I'll make good that point when I take you through them. But in any event, Miss Bajor's account of what happened is supported by the contemporaneous documentation. And so, insofar as Your Honour's got to weigh their translations alongside my translation and the contemporaneous documents, in my submission, the claimant still doesn't show that it has a case with a real prospect of success. I'd now like to delve, if I may, Your Honour, just straight into the evidence. And I would like to start just with a paragraph in Miss Bajor's evidence, which Your Honour will find at page 74 of the bundle.
Mr. Watson, why are you going to take me to this evidence? On the basis that I've already read it, is what I really mean.
In which case I can probably take it quite shortly. You will have seen that Miss Bajor gives a short account of the prior transactions that had happened on this account, those are dealings where Mr. Jafal had placed orders.
You're mute so far as I'm concerned, Mr. Watson. I can't hear a word.
Can you hear me now?
Bad network quality I've got coming up on my screen, so it's not your fault.
Can you want to hear me now?
I'm wondering if this is going to improve or whether I'm going to need to telephone in.
Can Mr. Dinesh hear me?
If you can hear me, can you raise your thumb?
I can hear.
Right. Okay. So it's my problem not hearing you.
I think Mr. Watson, the Honorable Judge can rejoin, I believe. I think he's gone out and come back.
Yeah.
Yeah. How long are you likely to take, Mr. Watson?
I don't know, at this pace, maybe 40 minutes.
I think your job is somewhat, yeah.
I'm back and I can hear you again, I think.
Excellent.
Sorry about that.
Well, Your Honour, I can probably take this point very shortly. It was to do with the prior transactions that Mr. Jafal had been conducting on the account, and which Mr. Al Khaili had approved by signing the portfolio documents. I don't know if you looked at one of those portfolio statements. I'd like to just take you to one, if I can, just to make good several points about the nature of the trading on this account. Perhaps if Your Honour could go to page 188 in the bundle. And you have to crane your head, unfortunately.
Yep, bear with me. Are you looking at the page number in the bottom right-hand corner?
Yes, but it should be in red.
Dark red. Okay, yeah.
Yeah, 188.
Yes.
This is a portfolio management report for the year ending, well, it's the year ending 2018. If you want to move down to the next page, 189, you'll see at the bottom of the page, it's actually on the left-hand side of the page, management type and objective, and it says management type, no mandate. Your Honour may have seen in the defence skeleton argument. Oh, have we lost the judge?
No, I'm still here. I can hear you.
Ah, your image had frozen. That there was a point made that the word sans mandat appears throughout the documentation, and it said, "Aha! Well, this is evidence that the defendant accepts that there was no mandate from Mr. Jafal." But that's not what is meant. What's meant by no mandate is that the defendant doesn't have a mandate to select investments, and one can see that quite clearly from the management type on the account. This is an account that's managed by the client, not by the bank or by the defendant. If you want to move to the next page, 190, you can see the signature of the claimant. It was said in submission that the claimant hasn't signed it, but there's his signature and date. Signing the present document, the client confirms he's examined the movements.
I think, to be fair, Mr. Watson, it's not said he didn't sign previous portfolio statements. He's simply saying he didn't sign one in respect of this transaction, whereas, of course, the statement would have come later anyway. So, in one sense, it's a neutral point.
If that is the point, then it is. I concede it's neutral. But as I read the skeleton, it was said that these old ones hadn't been signed. But perhaps Mr. Dinesh can make clear what his submission is. But if Your Honour would just go down to page 195 and 196 and just glance at them, Your Honour will see some examples of the sorts of transactions that are being carried out on this account. And it's a short point, but you'll see that it's relatively sophisticated trading. There's fairly frequent transactions for a variety, particularly on page 196, for a variety of different investments in all sorts of products. This is not an individual, or indeed, insofar as Mr. Jafar is managing it, his employees who are sort of unfamiliar with how any of this works. And if I could just show Your Honour as well.
Well, I'm no expert, Mr. Watson. Some of these are obviously ordinary shares. Some of them are pro notes. Some of them are pro notes, and there may be some derivatives in there. I can't really tell by looking. There's some foreign exchange.
There is some foreign exchange. I'll show you, Your Honour. If Your Honour could go to page 185.
And what I did notice was the reference to high risk in the portfolio statement.
Well, quite, and it must be high risk, Your Honour, because the client manages it. So.
Oh, I see.
Because I mean, he could, if he wanted to put all of his eggs on, incredibly.
What this means? It was under management objectives, so I was rather assuming it was the assessment that was made by those for whom you act, but it wouldn't be high risk simply because the client was making his own decisions, would it?
I don't think anything turns on this. Your Honour may be right, but I think as there's no evidence on it, perhaps we shouldn't explore it. But if you want to see at page 185, this is another example of a prior transaction.
Yeah.
In 2017, you'll see if you scroll down, Your Honour, this is a structured product, 3-year maturity, 100% capital guaranteed. It's an up and out certificate linked to the Euro Stocks 50 index. But just asking Your Honour to note how this transaction came about. It's summarised in an email, and then at the top there's a confirmation email. Dear Mr. Jafal, as discussed yesterday in our meeting, and as confirmed today by phone, we'll place the below order, and then there's an order summarised. So what happens is, Ms. Bajor meets with them in person, and then discusses what they would like, and then there's a confirmatory phone call, and you're going to see, Your Honour, precisely the same pattern in relation to what happens on the 3rd of July. So going to the relevant day, as you'll have seen from
this is simply a straight gamble on how the index performs over a period of 2 years, isn't it?
Quite. That is exactly what it is.
Yeah, I shouldn't describe these things as straight gambles, but that's what they are, in my humble opinion.
I wouldn't dissent from that, Your Honour. But maybe that's why we're lawyers.
Yes.
Just turning to the relevant sequence of events, Ms. Bajor's evidence is that there was a meeting in June at which the proposal was to invest the 175 million in a property transaction, and I don't think there's actually any dispute between my learned friend and I about that. No. The dispute comes because Ms. Bajor gives evidence that a few days later the claimant changed his mind and wanted to invest in various Islamic products. Now, the claimant is someone who changes his mind frequently, because there's no dispute that in a few more days' time he demands his money back. So the whole property transaction is off. So on his case, he changes his mind once in the space of a couple of weeks. The only difference between us is that I say he changed his mind twice, from property transactions to Islamic investments to can I have my money back, whereas his case is property investment to can I have my money back. At some points in his correspondence, he seems to suggest that the reason he asked for his money back was because he found out about these investments, but I'll show you on the evidence that's just not correct. Of course, Ms. Bajor's evidence about what happened at those meetings is completely unchallenged. There's a further meeting on the 3rd of July where Ms. Bajor presents the options, and this is a meeting attended by Mr. Jafal in person and the claimant on the telephone, and the claimant picks the investments that he wants, and Ms. Bajor says, I'm going to speak to Mr. Jafal over the phone to confirm and place the trades. And it's Ms. Bajor's evidence that at that meeting, the claimant said, yes, I want those investments. That is the evidence in support of the case that he authorised those investments. That's the primary evidence. I'll show you on the documents. There's also, even in their translations, evidence that the claimant authorised it. But the claimant has absolutely no answer to any of this on the evidence. So in my submission, I could just stop there because there's unchallenged evidence that the claimant approved the investment. It's said in the skeleton, well, there's no minute of that meeting on the 3rd of July, but that's not an objection that carries any force where there's no witness evidence from the claimant or Mr. Jafal. And as I'll show you, Ms. Bajor's evidence is supported by the surrounding documentation. So just to take things very clearly on the evening of the 3rd of July, the order of events is there's an email about the sukuks, then there's a call between Ms. Bajor and Mr. Jafal. While she's on the call, she sends an email about the Islamic notes. The orders are placed, and then she sends a confirmatory email about the sukuks, and then there's a second call about currency conversion and putting the remaining cash on deposit. And then there's email confirmations about the Islamic notes and email confirmations about the currency conversion and the deposit. And I'm going to take you to the some of those documents. Hopefully they should all be in the similar position in the bundle. But I'd just like to start at page 246 in the bundle.
If it helps you, it helped me. I printed off pages 246 to 313.
That may speed this up a fair amount. At 246, it starts with an email from Ms. Bajor to Mr. Jafal. Further to our meeting today. There obviously was a meeting. Please confirm placing the below orders in Sukuk issues as described in the attached list. So obviously her understanding, having come out of that meeting, as the document shows, is that they're going to be placing some orders for some Sukuks. We will send you a separate email, the capital guaranteed Islamic product with description. I'll call you now to place the orders. So that's the clear evidence about the purpose of this call. No response from Jafal to say, what are you talking about? This is a property deal. That's not what we discussed in the meeting. If the claimant's case is correct, that is what you would have seen, but it's not, and so you don't. You look at the next page, 247, one can see the list of the Sukuks set out there, and they come to a total of about 36 million US dollar. There are 15 listed there. You can take it from me, Your Honour. I'll show you why that's important in a moment.
It's the numbers, isn't it? 1, 2, 3, 4, and so on. Yeah.
Quite. At page 255, I'll show you this before we dive into the transcript.
Sorry, I'm just being curious and looking at what they were. But
a variety of different bonds in.
Yeah, they're just bonds of various kinds. Yeah. They
are, yes. And then at 255, this is the email that's sent. It's at the bottom of the page because the confirmation is at the top. It's the bottom of the page. Please find below the Islamic products we discussed today.
Yes.
So there's your contemporaneous document to support Ms. Bajor's account of the meeting. Again, no email to suggest that that was wrong. 100% capital guaranteed at maturity. That's the key bit. And then as you scroll, as I scroll down and Your Honour flips over the pages, one can see what they are. They are, again, essentially swaps in the sense that they are gambles on an interest rate, in this case, LIBOR. Certainly, sorry, maybe that's not right in relation to the first one, but the second one certainly.
One is.
Yes, sorry, that's my error. The second one is, the first one isn't. But you'll see that there's two there that are set out, quite clear, capital protection, 100% at maturity. That appears under both. It's quite clear what they were going to be buying. And so at page 252, we start with the transcript of the main call, and this is the critical call.
Yeah.
POA is Mr. Jafal, ruler is Miss Bajor. There's a little bit at the start where ruler's obviously dealing with a problem on the call. And then the point that Your Honour picked out, he's counting the number of products. He gets to 15 and she corrects him and says, well, actually, technically there's 16 because there are two different DIB securities. And they're going through to discussing them. She's giving various information about them. And he says, so the combined total is 36 million, but with and he gives a 36 million straight figure. And she says, yes, but there's with the accrued, but it will increase. I think she's talking there about the return. And then this is the top of page 253. There are purchase charges, which I'm lowering. It's 0.5%, which will reduce to 0.25%. And there's a back and forth between them as Jafar's trying to get a better rate on the commissions, and he gets a bit confused between his, because she says I'm going to get you 0.25 and he says no, I want 0.3, and she's, well, no, that's, I'm trying to do better. And then there's the crucial bit, do it then, okay, Abu Basel, you trust me, proceed. My submission, that's the instruction. He says, thank you very much. I know what I'm doing, you see, so for these we will execute them and we'll put a limit on the same prices as today. And then there is a rather curious exchange where he says, don't tell me I'm buying and selling, you're responsible. Indeed, you just tell me, ruler, for these we are in agreement as Sukuk. We're not in agreement, it's on your personal responsibility. And then they laugh. And then she says, tell Foward, I think that's someone in the claimant's offices, to write me in an email saying, OK, go ahead. And for the saying, OK, go ahead. Just pausing there, I think what's being suggested is that what she was saying is, I'm not going to execute these until you provide a written confirmation. In my submission, that's not the right way to read this. The order's been given. I think what they do is they have a joke about the fact that what Mr. Jafar is saying is that you're responsible, ruler, for getting the best price. And she's saying, yes, I know. Don't worry about that.
It's more complex than that, isn't it? It's the fact that there's a limit on what's going to be paid.
Exactly.
She's not going to buy unless the prices are less than today's. At least that's the way I would.
That's how the bank achieves the best price by placing the limit.
And that's why there is no purchase of sukuks in the end, because the price never drops.
Exactly, Your Honour. Exactly. And then one gets to the discussion about the two Islamic products, and for the other two products, did he print them for you? That's a reference to that email that I just showed you. Yes, he printed them. Okay, they are capital guaranteed as we discussed, and she describes them, and they discuss about the rates. And she points out, he says there's only one, where's the second one? No, they're after each other, this is over the page. Oh, okay, 1 and 2, yes, there's a line in the middle, as you can tell, and then a product called 5-year Islamic call. So that's the email that I've just shown you. 5 million in this, 5 million in the other one. And then he says, there's no need for any more phone calls. I don't want any, I want to travel. No, understood. I spoke to you enough, I spoke to you, enough calls. You take it forward as we agreed. With the capital guaranteed, that's the most important. Yes, 100%. It's also in the email. OK, as we agreed, go with God. In my submission, that's a clear instruction to place the order. He says, no more discussion. I just want to get on with this. And as Your Honour sees over the next page, I've already taken you to it, one gets immediately the confirmation email. You know, within half an hour, as confirmed by phone on my extension, we'll place 5 million in each of the below products. Again, no email comes back from Mr. Jafar saying you've completely misunderstood my instruction. It's left. It's quite clear then, I say on the evidence, what happened. I just want to show you, Your Honour, the claimant's translation of this, which Your Honour will find at page 622 in the bundle. And if Your Honour has it printed, it's the call on the 3rd of July, timed at 5:47.
Yeah, I'm afraid I printed it off from the attachments to the skeleton. So yes, I've got it. Anyway, I've got it.
You'll see it starts in much the same way. Did he print the second paper for you? I can't hear you. Hello, are you with me? Yes. And then one sees the counting again. 1, 2, 3, 4, and she's going through and pointing out the sukuks. I'm not going to take you through the sukuks because, as I say, they're not really relevant. But if Your Honour moves to the penultimate page in this translation,
yeah,
one gets about a third of the way down, and the second product, Jafal, it says, and the second product was also printed for you, the dragon products that we want to make. Now that's not Mr. Jafal, that's Miss Bajor. So I think there's an issue on these translations in identifying who's actually speaking. And under there it says, oh, print them with a badge. Okay, their dragons are capital guaranteed, like what we said, one based on the LIBOR, pays the LIBOR as a minimum. Again, this is Miss Bajor. This is not Mr. Jafal. But as I say, it's been incorrectly labelled. And if you want to move to the last line that's attributed to Jafal, another one, and then it's Bajor Air in a line of text if you see it, and then in a product called 5 years. So that's that bit I showed you where Mr. Jafal was struggling to identify it. And then it says, trust in God. This is over the next page. OK, so 5 million Baha'i and 5 million of. And then it says, there is no go ahead this call. I don't want to travel, which is odd because that's contrary to what I think was said in my learned friend's skeleton argument, which is their case is that he wanted to travel and didn't want to deal with any of these things. So that's not accurate. And then it says, I told you about this job and we wanted contacts. You took it, and as we agreed, if the capital is secured is the most important thing. Well, I can understand that if the capital is secured is the most important thing, because one saw that in my transcript, but the prior sentence just makes no sense. The next line, Bajor, true, false, 100%, written via Lin, written by email. I mean, that's just gibberish, Your Honour. And then it is written in the email exactly, take Abu Anas Hathal and it is your capital guaranteed. And then it just, Bajor and the sukuk I want to you, we also work in them as we agreed. I mean, when one stands back from these are not really a credible transcript of the conversation. They're not accurate. Your Honour doesn't need to work very hard to know that Miss Bajor probably didn't say written violin in the course of this conversation. So if there's any contest between the two transcripts, my transcript is the one that Your Honour should prefer. But in any event, as I've shown Your Honour, all the surrounding correspondence is consistent with what Miss Bajor says in her evidence happened. There was another call shortly afterwards about the conversion of the US dollar to the GBP to the dirham to US dollar, which is the necessary precondition to the purchase of the Islamic products. I won't take you to, Your Honour, you've probably read them. Even on their translation, I'll just make this point, I won't take you to it, but even on their translation, it's quite clear that an order is given to convert the dirham to dollar. And so you've got to ask yourself, why are they doing that? If this was a property transaction, as the claimant contends, why is Mr. Jafal on their own translation? We can look at it if Your Honour wants. It's the call that starts the 3rd of July 2019.
Yeah, 609.
Yes, it's
the last page.
It is. The 175 million, turn them into dollars, give me a good rate and trust in God. This is the order. Bajor done, Jafal buy. That's their translation. Now, if the claimant's case is right, that this is all a property deal, why is Mr. Jafal giving an instruction to convert a property deal in the UK, which would have been done in sterling? Why is Mr. Jafal giving an instruction to convert into US dollars? The answer is because that's not the deal at this stage. The plan had changed. And that's on their translation.
Yeah.
Your Honour may have seen then on, this is on the 3rd of July, the orders get placed, they're executed pretty quickly. On the 7th of July, there's an email from the defendant to Mr. Jafal, it's at page 275 in the bundle, confirming the orders that have been executed. So this is 4 days later. And it's set out in terms what has been purchased. No complaint whatsoever from Mr. Jafal. He doesn't immediately say, what are you doing? This is not what I instructed. He's had 4 days now with various emails making clear what was happening. No response whatsoever. That's because he had given the instruction. One then has a sequence of events where there's that letter sent. Firstly, Mr. Jafal gets in touch to say the claimant has changed his mind, and on the and can you send his money back? And Ms. Bajor starts to explain that actually, well, I can cancel the sukuks, but I have to sell these Islamic notes, and there might be a bit of a loss, and it'll take a little bit of time. And so I can convert the dollars that's just sitting in cash and send that now, but the rest is going to come later. I don't think a lot of this is really disputed. What I would like to show you, though, Your Honour, is the call that takes place on the 11th of July. And Your Honour will find that at page 288 in the bundle.
Yeah.
It's a short call with Mr. Jafal, and she says, Abu Basil, this is about 2/3 down, 1/3 down. Now you know the matter that happened with the administration, as I spoke to you about. This is an operation that's sizable with fees involved. Now the question that's being asked is, how does the client transfer this large sum and later on change his mind after we've invested a part of it? So we have to sell and return the funds as they were. And you know, Ruler, there's a cost, especially in Islamic investments. I told them correct, and the client, or rather his business manager, knows this. They said we received a letter. Are you with me? So there's panic because the bank have been given an instruction to return 175 million and they don't have it, and they're trying to work out what's gone wrong. And midway down, they've received a letter instructing a transfer of the full sum, and the client is awaiting their answer. We have to talk now. There was a management meeting that we have to now decide the way to inform the client that the sum is invested. Not all the funds are placed in cash. There are $10 million in capital guaranteed. Islamic investments have to be sold to work as well on the matter of how we sell the two products, because they've prepared a cost figure that was very high, 2%, which we're trying to negotiate something lower. So she's doing the best. You also know the process of an FX from US dollar to dirhams, which also include a difference from the initial amounts. They told me, does the client know of these things that occurred? I told them the client knows that we were buying sukuk and were buying capital guaranteed products because we spoke with him, as you know. They also said he must also know that we do not have the 175 million dirham. So what she's saying to Jafal in her call is she's saying, I was saying to the bank, I spoke to the client, he knows about all this. And she's saying, as you know, to Jafal. This is a document which, again, supports Miss Bajor's evidence about what happened at the meeting on the 3rd of July. Because what she's doing is recalling for Mr. Jafal the fact that there was a meeting with the client where all of this was explained. And that's what she's been saying to the bank. She's saying he knows about all this. So it's not our fault that there's a confusion. And I just want to show you their translation of this. It's at 6:40 in the bundle, but it's the call on the 11th of July at 4:17.
Yeah.
And it's the first page at the bottom. Miss Bajor, it's the same conversation that I've just highlighted. So they told me the customer knows about the things that have happened. I told them the customer knows that we are buying sukuk and we are buying capital guaranteed because we talked with him, like what you know from the office. Again, that's a reference to that meeting on the 3rd of July. That's their translation. It supports Miss Bajor's evidence. It supports my case. There was a meeting on the 3rd of July at which the customer was present and was perfectly content with what was going on, the buying of the sukuks and the capital guaranteed products. There were a couple of calls between Miss Bajor and the claimant directly. I don't know if Your Honour has looked at the minutes that Miss Bajor made of these. There's one that's particularly important at page 289 in the bundle.
Yes.
This was a call that took place on the 14th of July. You'll see in the top right-hand corner under the words creation date, the date 16th of July. So this note was made at least 2 days afterwards. Ruler Bajor with the ultimate beneficial owner. UBO contacted back RM on the mobile as he missed a call. RM explained to UBO that part of the initial capital was invested on the 3rd of July for 10 million and the remaining amounts kept in cash to be invested as per his and Ibrahim Jafar's instructions. There's a contemporary document. Again, no evidence to the contrary from the claimant that supports Miss Bajor's account. And the last bullet point of this, Your Honour, UBO replied that he didn't expect his instructions to have been executed immediately on that day. And that, in my submission, is the genesis of this dispute, is that the claimant is a man who is accustomed to changing his mind, and when he changes his mind, everyone just falls into lockstep. They just have to do what he says. And what he hadn't anticipated was that the bank would execute his instructions on the next trading day, so that by the time he changed his mind, he was already committed. No evidence to contradict that contemporaneous document. And I'll show you just 2 more documents, Your Honour. Firstly, at page 326.
Sorry, I'm having to scroll to get that, and it always takes me longer. Yes.
This is a contact report. This was a meeting with the claimant attended by Miss Bajor on the 15th of September, and the note was made on the 17th of September, a few days later. Meeting was arranged with the ultimate beneficial owner to clarify the points regarding his complaint. By this point, he's complained that he wants his money back. RM explained we've invested in Islamic Sharia assets based on his instructions by phone on the 1st of July. That's because he was attending that meeting by phone. And 3rd of July on the mobile of his power of attorney, Mr. Jafar. We've always had a very good relation with them since 2006. And then the 3rd bullet point, UBO insisted on refunding his loss, whether it's done by the bank or, I think that should be or, POA. He claimed that he never gave any instruction at all to invest the money and that it was done without his knowledge and his confirmation. The MD decided on his own to do the investment with the bank. I think the MD is a reference to Mr. Jafar, because I think that's the only person who could be intended to be the managing director. I don't know why she doesn't say POA, but what's happening is the ultimate beneficial owner, the claimant, is blaming everybody else He says, I didn't do this. This is you were all acting without authority. This is where it's come. But Miss Bajor's position hasn't changed, and she's trying to explain to him, no, you did give these instructions. But by this point, the claimant has become rigid in his attitude, and he says, look, it's either Mr. Jafal's fault or it's your fault. It's certainly not my fault, is his position. And I just want to show you one last document, which is 2 pages long, at 328. And this was an email that recorded the minutes of a meeting with Mr. Jafal in September. They've gone to see the Difc governor to complain about what's happened. And Mr. Jafal informed the bank that the UBO is still denying that he gave him and Ruler instructions to invest in securities. And this is a crucial line. POA mentioned that he will not oppose the UBO's will and that he has to find a way to refund him the loss. And that's what gives the game away. Mr. Jafal is in a difficult position because he's got a boss who has changed his mind and now refuses to accept that he's done so. And poor Mr. Jafal has to find a solution. And either Mr. Jafal is on the hook or the bank is on the hook. And so he's trying to sort of say to the bank, look, help me out here. I can't disagree with him. We've got to find a way around it. But the problem is the bank stands firm. And partway down, POA was sure that he mentioned over the recorded line that he was not interested in he was not involved in investments, as he was travelling the next day and didn't want to be disturbed with calls. Well, as Your Honour has seen, he was travelling and he didn't want to be disturbed with calls. But that was that was part of a conversation where he was saying, "Look, just do it. I don't want to deal with any more of this." And he had the emails that confirmed what was going on and didn't say anything. And this is the point at which he starts to distance himself from what happened and say, well, actually, I didn't give the instructions. But as is made very clear to him, all the instructions are placed over recorded lines, and the bank's followed its protocols. And it's at this stage that it moves into the pre-action correspondence. Various points are taken in the pre-action correspondence that are not now taken. So it was said that the mandate expired after 3 years, and there were various other issues taken. I'm not going to trouble Your Honour with them because they don't seem to have been pursued. But just by way of summary, if it wasn't already clear, there's nothing in my submission that the claimant can say to any of this. It's quite clear the transaction was authorised and then countermanded, and that led to the loss. There's no evidence from anyone to the contrary. If Your Honour stands back and asks the question, is this a claim with some reality? The answer is no. There's no good reason for a trial to take place. It would just consist of the submissions that I've made now. Your Honour should grasp the nettle and dismiss this claim. Unless there's anything particular I can assist you with, those are my submissions.
Yes, thank you, Mr. Watson. Mr. Dinesh.
Thank you, Your Honour, and thank you, Mr. Watson. I hope that I'm audible now.
Yes, thank you.
Yeah. Of course, I can summarize the broad point which the defendant, my learned friend, has explained, that this is not a case for evidence, number one. Number two, of course, there are factual issues and there are telephonic conversations. Of course, those things are not, there are recorded conversations and non-recorded conversations. My endeavor would be to show, because that is what at this stage I need to prove, that this case requires a trial, because this case is elementarily based on factual issues. Broadly, I would like to put the whole issue into two broad perspectives. One is whether this transaction, because I'm also confining to leaving alone other sides, because Your Honour is also concerned about what is the nature of the transaction and whether there was an instruction or not, express instruction or not. So I would like to broadly classify as a transaction whether there was an authority, one. And the other side, even assuming for a moment that there was an authority, whether there was an express authority instruction given to execute the trade or not. That is the broad two aspects. And apart from that, so far as this transaction is concerned, there are two aspects. One is a pre-sale order, pre-purchase part. The second is the post-transaction correspondence and meetings between the parties. Before going into this aspect, we have to understand the role of each party here. The defendant is an advisory firm. Defendant's role, which is coming out of the agreements, which I don't want to take into because there is no much of a debate or dispute on that aspect. Defendant is an advisory firm, which is a subsidiary of the Geneva-based bank. There's BNP Swiss Bank, and they have various products internationally. They sell in about 30 countries, and they have a firm in the Dfc. Then they have to go by the rules of Dfsa authority and rules and regulations. And the limited role is to advise clients what should be the nature of your investment and what best return you can get. Just an advisory role. And their advisory role is also limited to the professional clients because they can't advise to, as per the rule, they can't advise to. That is also an admitted fact, which I don't want to dispute as per the rules only. They can only give advices to the corporates or certain professional clients. My respectful submission is that my client or the claimant is not a professional client. Of course, in the agreement, they mentioned that he is a professional client because DFC, this agency can, the Paribas, the defendant can engage business only with the professional clients, not retail persons or individual persons as per the rule. And professional client stands on a different footing. Professional clients means you have to treat, not suppose if a professional client is not a corporate entity and if he's an individual or a deemed professional client, in that case, you have to deal with the client alone. I don't want to read that because that is also as per the rules of Dfsa. Dfsa rules says that if the professional client, I just can give you the rules which we can refer to later, that is conduct of business rules, kindly make a mark of it. Conduct of business rules 2.3.4. 2.3.14 precisely. 2.3.13 precisely. I just read out because it's only a rule which nobody can dispute. If I just read out, it's only 4 lines. If an authorized firm is aware that a person, that is the agent, with or for whom it is intended to carry on financial services, is acting as an agent for another person, the principal, in relation to the service, then, unless the agent is another authorized firm or a regulated financial institution, the authorized firm must treat the principal as its clients in relation to that service. So the meaning is that if the financial service is provided to an institution, then in that case, they have to deal with that institution alone. Services is given to an institution or a corporate. There are various types of clients in the Dfsa. So this professional service, professional client, if he's an institution, then you have to deal with the authority, the institution per se. Suppose there is a provision for deemed professional client. If he's a deemed professional client, like this case, where a person having high net worth, in that case, the defendant is supposed to deal with only the client, not his agent. So the first limb of my submission is that the entire transaction was not with, so far as purchase of this two Islamic guaranteed instrument, which is 5 million each US dollars, is not with a client, a person called a client's representative, who has no mandate. Because when we look at the contract note, I'll just take your honor to those pages. The contract note refers client's representative. Of course, I can straight away take two, because kindly come to 245 of the running page of the bundle, 245. Your Honor, got it?
No, hang on.
Yeah.
Yes.
Yes. Kindly come to the top of the page, contract note, that is their instrument, which they produced. Kindly see the management type, top of it.
Yes.
The contract note management type, just below sans mandate.
Yes.
Sans mandate means there is no mandate. Then, going on, kindly come to page 248. On the top of it, that is the crucial date, they say client's representatives. So all other contract notes thereafter and refers to only the client's representative, and some places, particularly at page 251, there are so many notes, so many documents. I don't want to take this honorable quote to every document. 251 sans mandate. So I just summarize my submission so far as the first limb of it is concerned, that this entire transaction was with a person who has no authority to transact. This will be more evident from the fact that admittedly on the crucial date of 3rd of July 2019, the client was on a call with the client's representative according to their own term. So the discussion, there were two discussions prior to that. At that point of time, they were conscious of the fact that, look, while we are going to enter into a contract, it should be with the client alone, or there should be an authority from the client directly. So that was the reason why on 3rd of July, before everything starts, there was client on call. And I've gone through the written submission. They have mentioned that this is the practice in UAE, that high net worth individuals, they will not look into small investments. They always depute a person, and he will be the person who will be dealing with all kinds of investments, etc. But on the contrary, so far as facts of this particular case is concerned, there was an active participation by the client. That is an admitted fact. So what they have done is they have selectively included the presence of the client, not the client's agent, the supposed client's agent, whenever it was suiting to them, when it suits to them, and whenever they don't require, whenever it is not possible to explain the contract, they bring in the client's representative. So my respectful submission, so far as the first argument is concerned, the whole transaction was without authority. And I'm coming to the second part where the argument took place. That is, Mr. Jafal was the agent and he was acting on behalf of the client. I'm assuming for a moment that Mr. Jafal, as per the argument, only for the sake of arguments, that Jafal was having the entire authority to act on behalf of Mr. Ali Khaili. Then, when we look at, I would like to read the evidence, and evidence would show a different picture, altogether different picture. I can also substantiate, I'll come to that aspect, that there was no express instruction to buy these two documents, instruments, that is 5 million each Islamic guaranteed instrument. So for that, before that, coming into that aspect, I straight away invite this Honorable Court's attention to the affidavit of Mr. Rola Bashur. I hope that I spell correct, Mr. Watson, because yes. Rola Bashur, kindly come to page 68.
Yeah.
Yes. Before that, I just want to give a small, I just want to mention that, as I mentioned earlier, the entire arguments, entire case is built upon for this immediate judgment is based on evidence produced by Ms. Rola Bashur. Of course, I would like to mention that the last date of receipt of our witness statement as per the case management document was 18 November 2019. Unfortunately, before that, this hearing took place. So our Mr. Jafal would be a witness. I'll substantiate and I'll come to that part. I just want to mention that that is my instruction. I'll substantiate that. But before going into this aspect, kindly come to what is the issue in this case. There are two aspects of the transaction. Kindly come to page 77. That is part of our affidavit. Then I'll go back and come back again. Page 77. 3rd of July 2019 is the crucial date. Kindly come to para 42. Page 77, para 42.
Yes, I have it.
Yes. There are, so after assuming for a moment that there was an active order to place active instruction, kindly come to 42. Immediately after my calls, Mr. Jafal on 3rd of July 19, I had given the instructions to internally to BNPP to effect the orders, to summarize as this follows: to convert $175 million dirhams to US dollars. That is one instruction she talks about. Of course, there was an argument to the effect that why it should be converted. It should be converted for the currency exchange rate and to get to benefit out of it. So why? Because for the purpose of purchase of a London property, it should be in sterlings. Why it has been converted to US dollars? My answer to that is it was conversions were required because money was lying there, and to gain the international currency exchange, whatever the benefit I get, that is the reason for conversion. And kindly come to the second B, to place an order to buy 36 million US dollars, 36 million Sukuks that we had discussed, but with a limit on the order so that no transaction would take place until the Sukuk price was below the price on 3rd July 2013, to place an order to buy 5 million US dollars each Islamic product. So she's talking about three aspects, broadly three aspects. One is conversion of 175 dirhams to dollars. Second, $36 million worth sukuks. And the third is $5 million of Islamic guaranteed instrument that is called Islamic product here. So broadly, the whole discussion between the parties were on two aspects. Basically, my respectful submission is, so far as the entire discussion between the parties were only confined to purchase of sukuks. And there was no discussion. There was a discussion and passing references between the parties. So far as purchase of US, the $5 million, that is the issue in this present case, the $5 million purchase of $5 million worth Islamic instrument. And this Islamic instrument, while talking to Mr. Jafal, the Islamic instrument also came in between. I'll just take this wonderful quote to that aspect from the evidence itself, from the witness statement itself, that was a passing reference to the Islamic instrument. But so far as Islamic instrument is concerned, there was no express instruction to purchase. That was sneaked through. That came through during the transaction, during the conversation. So before that, how the relationship started is very important. Kindly come to page 75 of the witness statement. And on top of it, kindly come to more precisely page 74 bottom.
Yes.
On June 2019, I attended a meeting, His Highness Al Khail's office at Abu Dhabi, so and so, and 175 million UAE dirhams would be transferred to His Highness Al Khail's account with the BNP Swiss before the end of June. Mr. Jafal said that the intention was for the funds to be used as a collateral to finance a property in London worth around 90 million pounds. Mr. Jafal said that intention was to place the funds on 3-month deposits. So that was the intention. Intention was to place the funds for 3 months deposit pending the acquisition of the London property. He asked me to find a high paying deposit. I said I would discuss internally and we would do once the funds of His Highness Khalil amount. I made an internal live note of this meeting a few days later on 27 June 2019. So the whole discussion was to purchase the whole, because before that we should bear one aspect in mind, that this entire account was dormant and the zero balance account for more than 2 years. Because the defendant pointed out certain transactions between the claimant and the claimant and defendant pertaining to 2017 and 2018, and which during the course of arguments of defendant also pointed out that there is a reference to KYC notes. The KYC notes very specifically, as per Dfsa rules, it states that when an account is not active for more than 12 months, there should be a fresh KYC. So fresh KYC means who is a client, anybody is acting on behalf of the client, all those particulars coming under KYC norms. So far as this case is concerned, this account balance was zero and there was no activity at all. This particular account is concerned. And this started later by transfer of this 175 million dirhams. So that KYC, violation of KYC norms, because the fundamental issue which really is because the non-collection of KYC documents or not following the KYC regulation, that is a fundamental error or the mistake happened on the part of the defendant. Had they collected KYC documents, had they performed their obligation, then this would not have, the whole issue would not have happened. There would have been client alone to deal with or an authorized person on behalf of the client. Leave that as it may for the time being. So far this transaction is concerned, the entire meeting took place for the purpose of purchase of property in UK, and there was some delay in purchase of the property. So till then, what should be done with this money? Suggestion came, okay, let that be with an interest-bearing deposit for 3 months, because that may take the short-term investment. Then come to E2. I'm requesting this Honorable Court's attention to para E2, page 75, the same page.
Mm-hmm.
Yes. This is how the whole issue starts. 1st of July 2019, I attended another meeting at His Highness, I'm just calling His Highness for the purpose of easiness, His Highness office in Abu Dhabi. Mr. Jafal was also present. His Highness joined by telephone. So he joined by telephone. On the speakerphone, Mr. Jafal's office. The purpose of the meeting was to discuss what would happen to the funds that have been transferred to His Highness account although His Highness had originally intended to use these funds for a potential London property investment, he now said that he had changed his mind and wanted the funds to be invested in Islamic products and sukuks. I said I would prepare a selection of the products that might be suitable. So this is an interested statement, of course, a witness, which subject to cross-examination, we would be able to elicit more. Her statement is that he changed his mind. That was the crux of the argument. Though the property, the entire investment was for the purchase of property, there was a discussion to purchase certain Islamic instrument. And I just point out one more aspect. Of course, there was some sort of a consensus to have it for a period of 3 months. That I read out that till then, for the 3 months period deposit, that is the top of the page, intention was to place the funds on 3 months deposit. So the whole intention of the parties and what was decided was till the purchase of the property, let that be with certain instruments so that that will have some sort of an income. Now, coming to the crucial aspect and the crucial day, that is 3rd of July 2019. I had a further, kindly come to page 32, para 32, same page 75. On 3rd July 2019, I had a further meeting with His Highness office in Abu Dhabi. Mr. Jafal was present and His Highness joined by telephone. So that is also he joined by telephone. I can take this honorable court to the submissions they made that high net worth individuals will not participate in any of the transactions. Everything is done through the representative. That is not correct. He also joined the telephone call, joined the telephone again, and on a speaker phone in Mr. Jafal's office. I had prepared a selection of potential investments. We discussed them one by one, thoroughly and detailed. His Highness confirmed the products that he is interested in investing in. These were the sukuk issues and Islamic capital guarantee products. This is an addition there. The entire discussion was, my respectful submission was only on sukuks. These were the sukuk issues and Islamic capital guaranteed products that we had discussed. So there is these two were added here from the part of the witness, which I can elicit during the course of cross-examination with the contemporaneous documents and her own statements, which I'll read through later. So of course, I also accept. I said, assuming for a moment that the second limb of my argument is, which I'm going through now, is that assuming for a moment that Mr. Jafal has got the authority, whether there was an active instruction or not. So for the purpose of this, I'm just reading this out, saying that there was a discussion, of course, for the purpose of purchasing sukuks. Then kindly come to, I'll straight away come to the evidence which was read out, which Your Honor is also very, multiple times might have read about this issue. I would like to invite this Honorable Court's attention to the evidence once again. Kindly come to page kindly come to page 246. So everything starts from this crucial day, and whole transaction took place on 3rd. My respectful submission why there is a realistic prospects of trial and there is a realistic chance to succeed in the trial is that there is an element of dishonesty in this entire transaction. And the leading case, which is GFH Capital versus David Lawrence High, which is the leading case which has been mentioned, so far as immediate judgment is concerned, there it has been very explained that there is an element of dishonesty. The matter, of course, subject to court's jurisdiction, is likely to end up in trial. The question here is, why reading through this witness statement, whether there is an element of dishonesty on the part of an advisory agency, whether there is an element of misrepresentation, whether there is an element of bringing something which was never discussed in a clandestine style and misrepresented the party and purchase the order without an express direction, express mandate or not. If I succeed in that endeavor, my respectful submission is that this is a matter for trial. So before that, I just take to the, because to substantiate my argument, I would like to say one more aspect that on, I'm sorry, at page 35, I invite this Honorable Court's attention to page 35, because my statement is not without pleadings or not based on any document. I just want to substantiate that aspect. Page 35. Kindly come to page 35. This is the reaction of the client, the original client, not current client's representative.
I'm sorry, I'm not with you. Which page you're trying to want me to
Page
look at?
35 of the case bundle. Page
Oh,
35. 35.
Right. Okay.
I'm sorry to take this Honorable Court back and forth because.
No. Yes, 35.
Yes, kindly come to, these are all earlier references, etc. Of course, the issue here is 660 million dirhams. That is the first part dealing with saying that I'm short of this much. You have done this. And kindly come to the second para. As your letter is full of fallacies and manipulation of my funds without informing me and taking my approval, which is explained to Mr. Raula Bashar and Mr. Bashar during the visit to my house at Alain City, and explained to them my opinion. I have no relations with all these manipulations of my funds, my Raula Bashar and her assistants. And kindly come to the next page. We can leave things for the purpose of nothing material. Next page is Mrs. Raula Bashar communicated with me to offer to buy a building in London, subject to which the amount was transferred to your account, which you in preparation to buy the building and take a loan from your bank for the amount remaining from the building price. But I was surprised with these investments that you claim without telling me, which led me to immediately refund the amount to my account from which the amount was transferred to protect my funds, which are wasted by your employees. Attached copy and so on and so on. So now I'm inviting again back to page 246. So there, the reaction of my client is that there is a manipulation with my funds. How this manipulation has taken place is which I would like to demonstrate. Kindly come to page 246 once again. I'll take once again, I would like to read the evidence in my own way. Of course, there may be a different perception altogether, maybe appealing to the court. I'm just making an endeavor. Kindly see the whole discussion starts at 5:30. I'll just read that. Further to our meeting today, referring to the earlier meeting where the original client was on telephone line. Further to our meeting today, please confirm placing the below orders in Cooke's issues as described in the attached list. We will send you a separate email, the capital guaranteed Islamic product with description. I'll call you now to place the orders. So far as Cooke is concerned, the discussion took place, and there is a reference that whole discussion was about Cooke's, and so far as capital guaranteed Islamic product is concerned, she is going to send. Now, kindly come to next 248 and 247, which was shown to Your Honor, page 247. That is below. It can be shown. It can be seen. $36 million total gross with account, etc., etc. That is 247. These are all Cooke's. Page 37, 247. I'm sorry, page 247.
Yeah.
Page 247 talks about Cooke's, which they discussed, and there is a reference at 5:30. So these are the various products of Cooke's, which I earlier shown that $36 million. Sum total is $36 million. Then coming to, because I just want to establish and show that was there an express instruction to buy the Islamic product or not, Islamic guaranteed product of 5 million each. Kindly come to 648, 248, page 248. And I'll be taking sequentially the pages. This mail is the content, investment related placement of confirmation, the clients in the middle of the page. That is 248 in the middle of the page.
Yes.
Yeah. May I?
You can assume I'm following you.
Yeah, thank you. 648, Mr. Jafar, as discussed earlier by phone, so and so 609. That is a last call. We will convert dirhams to USD at the best rate given in the market, and we'll place remaining amount in saving on call after we invest the money as per our proposal. So there was a proposal by the advisory services, that is defendant, and the kindly note this timings are very important. Timings and dates are very important. The whole transaction took place on 3rd of July, and timings and dates are important. So, and the sequence 609, because she is referring to a call of 609, we'll convert AED. The transaction is we'll convert. There is no 609. She doesn't talk about anything else. She says I'll convert, and as per proposal, whatever the balance amount, we'll be doing it and converting it. And kindly come to the next page, 249. This is 606. So she's talking about a conversation at 609, and this is a mail at 606. As confirmed by phone, my extension so-and-so 554, I will place a buy orders for the below sukuks a limit or better. So up to 554, there was no transaction, there was no discussion so far as placing of orders on Islamic guaranteed instrument of $10 million total. Up to 554. Kindly mark that. 554, there was nothing so far as Islamic guaranteed instrument is concerned. Now, kindly come to the conversation, because I go by, of course, I have an argument that this transcript is not correct transcript, but for simplifying the issue, for the purpose of this honorable court, I just rely on the transcript produced by the defendant, except one aspect which was read out, that no go through. There was a specifically mentioned that in the transaction earlier, which I'll take no go ahead. There was a specific word which I'll rely on, which is missing in the transcript produced by the defendant, but earlier transcript which was read out, and this honorable court also saw the line no go ahead, means keep it apart. No go ahead call was also given by Jafar when they were concluding the conversation. So I'll just rely on that for the purpose which was read out by my learned friend. So kindly come to this aspect. They talk about this. Before that, and this call starts at 547, page 252. And this is the longest call according to them. And they discussed everything. They produced as part of the witness statement as well. And this call materialized everything. And these numbers 1, 2, 3, 4, 5, 6, these are all with sukuks. Nothing to do with this Islamic bond, Islamic instrument. Now, kindly come to the bottom of this page. They talk about $36 million and 327, which I've shown those instruments in the earlier page, sum total of that figure. Then she introducing, while talking, she says, yes, proceed. My learned friend read proceed in the middle of page 253 as if a proceed for purchase of Islamic bond.
No,
Islamic, it is not.
No,
I'm so sorry. I'm so sorry. I understood my mistake then. Because the
we
emphasis
can all
was.
see that relates to the sukuks.
Yeah, fine. I thought it was proceed in the sense it was only for this thing. I'm so sorry. I apologize. Then kindly come to the bottom of it. I apologize, Mr. Watson. I'm so sorry. I understood in that way. Raula, okay, kindly come to the last part of that statement. Okay, they are capital guaranteed as we discussed. One is based on LIBOR, paying that LIBOR pays minimum 2.3 if charges will change in 3 years, etc. For this, we will invest 5 million. They talk about this 5 million here. And because 3 years, euro, dollar, so and so. And she says, yes. And just before that, this Rolla, okay. This honorable court got it. Rolla, okay. That page, bottom of the page 253.
Yeah.
Yes, just above, she's inquiring. I've sent you certain this Islamic guaranteed note. Did you get that? Did your assistant print it for you or not? He says, yes, he printed. And this gentleman says, I got only one. Then she says, proceed. Next page 254. She says, no, there is one more. She says, there are two. Then he says, go down. I can see the next attachment. And she says, yes, okay, 1 and 2. Yes, there is a line in the middle, as you can tell, and so and so, so and so. And there is no need for any more calls. I don't want any. So there is no, and he says, I need 100% return. It is all written in the email, she says. So so far as this discussion about the great advisory services is confined to only a seconds where she is introducing the concept of $5 million just for 1 or 2 seconds and telling this gentleman, please have this also. Anyway, you give me an instruction to proceed with the Sukuks, and she's trying to sell one more product, not of any other party, of the product of Bnp Paribas. Same company's product. Now, kindly come to the next page, 255. Kindly see 553, bottom. Kindly see bottom 553. So this, she says everything happened this very same call, which was initiated at 547. At page 562, the call initiates and the duration is 6 minutes and 12 seconds. Yes. And she says everything happened, and kindly come to the bottom of it. Please find below 255 bottom. Please find below the Islamic products we discussed today, which are 100% capital guaranteed at maturity. Minimum order is $5 million. And my learned friend did not read this part. The next line, I noticed that I'll call you to discuss both. This was, though it was read out to this honorable court, this line was not read out. So 553, please find below the Islamic product we discussed today, which are 100% capital guaranteed at maturity. Minimum order is so and so. She's canvassing again. I will call you to discuss both. So her stand at 553 is that we will be discussing about Islamic bond. I'll call you and discuss about Islamic bond. Yeah. At 553. Now, kindly come to the last call. That is 609. Yeah. And this 609 is the last call between the parties. So 553, there was no confirmation. And if at all there was a confirmation, that should happen in this call. Admittedly, there is no other call apart from 609 call between the parties, except certain personal calls, which I record the witness for cross-examination. I'll submit that. Kindly come to 609. I would like to read out this only 1.5 pages, complete to understand. Hello. I'm relying on the transcript. Raula, may I read this, Honorable Court? May I read this? It's only 1.5 page.
Well, I've read it. I know what it says.
Yeah.
It's
still kindly
all to do with the conversion rates of the Durham.
Yeah, only conversion rates. So this gentleman, last part of it, kindly see, and just before that, see, kindly come to one aspect of it.
Yeah.
I just read two. I would like to read it once again. It's already 1.5 pages. I'm requesting for reading it. May I read that? Just to understand in a proper perception.
Just
my own satisfaction.
I've read it. I know what's in it. Tell me what point you want to make about.
Then kindly, I follow. Kindly come to 261 for a moment. Top.
Yes.
4 lines.
Thank you.
Yes. Rola says, okay, great, inshallah. God, we agree. I will give you another call because we are not supposed to call on this. So there is an internal call between these two parties while this is a recorded call. She is reminding this gentleman that, look, this is a recorded line in the middle of page 260. She's reminding, when this person was talking something else, she's reminding him, look, this is a recorded call. Then she says, I will give you another call because we are not supposed to call on this. There was a discussion between these two parties about the previous is only they're discussing about only $5 million and $25 million and $50 million, etc. And straight away she says, we are not supposed to call on a private call. We'll call it later on. Rola, my phone is recorded. Therefore, there will be contradiction between my call and yours. No, there is no contradiction. I'm taking order from you. And now let me call you to tell you, I will place the order in deposit and tell me, yes, done. And 175 million, convert them to dollars. This is the final terminating sentence. He says he's sticking to his point. He says, convert $175 million to 1 million dirhams to dollars for the purpose of exchange rate. So my respectful submission so far as reading of this particular evidence, particularly admittedly the last call of 609 says 553, she says, I will be sending the Islamic document and we will discuss on them. 553 previous page. And this is the next call thereafter. So 553 and 609, nothing has happened. 609, this gentleman says convert 175 to dirhams, dollars. And in 609 call, she talks about a private call in between the parties. That is not recorded. No evidence. No statement on that aspect. And she's reminding our calls are recorded. And concluding paragraph is convert that. So this is the last call. So from this is the previous, this is what really transpired on 3rd of July. So my respectful submission from this, is it a case for an immediate judgment? That is my respectful submission. When the parties are discussing, I can also take this honorable court to various other conversation, and there are cell number calls because she says post-transaction, the client, His Highness, called her on her cell number. That is not recorded. So that is only a subjective presentation of the witness, her own statement. And if the statement remain unchallenged, justice won't be done. That is because the trial is for the purpose of seeing who is right and who is not. And the immediate judgment is a case where if prima facie in this is prima facie out of prima facie, if there is no case and a person can be knocked out straight away, fine. There can be a case for immediate judgment. But here is a case full of factual matrix, which talks about witness personal conversation, unrecorded conversations, subjective comments, and a decision for a guaranteed Islamic bond for 5 years taking place in, according to her own statement, in minutes. It is not something which is a future market where minute by minute the rate changes. This is something which is lasting for 5 years. And this is something which is a guaranteed return in Islamic product, which is a guaranteed return invested for 5 years. And a decision need not be taken in 1 minute or 1 second. Here only few seconds. And the role of advisory services is to give a concrete advice as per their own agreement. It's only an advisory service. It's nothing to do with the bank. And bank is, of course, they're all beneficiary. There is a subsidiary of the original bank, and they are selling the bank's product here. They're pushing the bank product to a gullible customer. And her whole endeavor is somehow sell it. They can't wait for 24 hours. They can ask the client, because she knows very well, the client participated in the Cooke meeting, the client participated in the earlier discussion to purchase the property, and why can't she wait for a few minutes more, at least 24 hours, to purchase a 5-year guaranteed product? So my respectful submission is, this entire thing, there are something more than what meeting the eye, and that has to be brought in, and can be brought in only by subjecting Ms. Rola Boja to cross-examination. I would like to elicit what really transacted, and assuming for a moment that this gentleman has got authority to act on his behalf, was there any express authority? When did you get this authority in few seconds? What time? What was the discussion between you and this gentleman happened during over the phone? Nothing has come out. So it has to come from the witness alone. And my respectful submission, this case can be proved only by a trial. That is all my respectful submission. All other technical aspects, etc., I'm just leaving out because this is the factual issue. This factual issue can be determined only by bringing the parties. And here I need only Rola Major Bashar. I can establish my case from Rola Bashar. I can produce my witness also. Because my instruction is that was submitted on 18th. 18th is as per the case management document. It is the last day for producing the witness statement, and it was done. But before that, it was the date was fixed. Leave that aside for a moment. From their own statement, I can. This is an open and shut case. I can, by cross-examination. My respectful submission is this is enough, but by cross-examination, I can, subject to cross-examining the witness, I can elicit more and say that this is a case without any authority, so far as Islamic bond is concerned. That's my respectful submission.
Thank you, Mr. Dinesh. Mr. Watson, the only thing I want to hear you on at all is the question of Dfsa rules and guidance. I'm fully aware there's no pleaded point, but leave aside that for the moment.
It isn't. There was a new point that emerged in my learned friend's oral submissions that hadn't even been prefaced in his skeleton argument, that there is some provision of the code of the conduct of business rulebook that says that where one has a professional client who's not an institution, this was his submission, you can't have a mandate. You have to deal with the client directly. I've been scouring the rules and I can't find the rule that has that effect. It would be extraordinary if that rule had an effect. There is nothing impermissible about the mandate arrangement that was put in place. There's been no properly developed argument before you that I can understand about why anything in the Dfsa rules would not permit the bank or indeed the defendant to rely on Mr. Jafal's instructions, given the documents that exist. So that's the first point. The second point seems to be something to do with KYC, and again, I don't think Mr. Dinesh actually took Your Honour to a specific rule and showed it to us. I mean, the conduct of business rule, the point came so late. The document he's relying on isn't even in the bundle, and I haven't got a copy of it. And it's completely unacceptable to just bring authorities and read them out without providing them properly. But leaving that aside, in relation to the know your client, I just don't understand what the submission is. I mean, is this submission that because the bank or because the defendant didn't carry out some know your client check when when the claimant re-engaged with the bank after his account had been emptied, that somehow that invalidated the mandate? I mean, there is no rule to that effect in the DFSA's rulebook, and Mr. Dinesh hasn't shown you, certainly hasn't shown me, a rule that in terms that says that. So this point just goes, even if he were entitled to take it, and he's not, and he wouldn't be entitled to take it at trial because it's a point that needs to be pleaded, it just doesn't go anywhere. And I can't see really that an arguable case has been made out at all.
Next, if you're going to rely on any rule at all, I need to see what the rule is.
Yes. I'm so sorry. I'll just refer to the rules. I'll just produce it. It's part of the one rule is produced as part of the latest document. I'm not in a position to give you the pagination. And the pagination, I'm told that there is 654 running page. I don't have because it's I'm using slightly old 654. Internal page 12. 654, 656, and 657. That is a document that is my instruction.
Right.
Yeah, and internal page 12, kindly come to internal page 12, bottom of the page. On top of it, anti-money laundering, and the bottom of it is 12. This honorable got it?
Just getting there.
Yeah.
Yes, I have it.
Yeah, kindly come to 8ED, bottom. If a customer account is dormant or an authorized firm has had no contact with the customer within a previous 12 months, an authorized firm should take reasonable steps to verify whether available information, documentation, and evidence concerning the customer is still valid and up to date. That is part of the KYC rules, which I have referred to my skeleton arguments. And well, of course, Mr. Watson, I did not interrupt you. Let me complete this. And second, of course, my apology for that, because it's not part of the bundle. Yeah. That is conduct of business rules. Kindly make a mark of it. Conduct of business rules, since it is a document of Dfsa. Conduct of business rules 2.3.13.
Yes, and what does that say?
This says, if an authorized firm is aware that a person, the agent, with whom or whom it is intended to carry on financial services, is acting as an agent for another person, the principal, in relation to the service, then unless the agent is another authorized firm, if an agent is another authorized firm, there is no issue, or a regulated financial institution, the authorized firm must treat the principal as its client in relation to that service.
Well, so I understand that, but that doesn't help you.
Yeah, my only endeavor is that he should deal with the client first straight away.
I understand.
Because, yeah.
I understood. All right, thank you very much. Well, that I at least understand what's going on. I shall give written reasons for my decision, but I'm quite clear in my own mind that the defendant has, the claimant has no real prospect of success at all in this case, because the evidence is quite clear that authority was given, that there was approval both by the claimant himself and by his power of attorney, Mr. Jafal, and the documents established to my satisfaction that everything that is said on evidence in affidavit by Ms. Bajour is accurate and correct. There is no evidence to the contrary, and in circumstances where the claimant has chosen not to put in any evidence on this application, and at least as I understand it, has not put in any evidence at all in relation to the trial that is proposed for February, there is no basis upon which this claim could possibly succeed. And in those circumstances, the right thing to do is to give immediate judgment in favour of the defendant. I'll set out my reasons for that in writing, which you'll get, well, probably tomorrow now, by the time I've sent it to the court and the court has issued it to you, being whatever time it is in Dubai now, though still morning where I am. Costs, Mr. Watson?
Given your lordship's order, I seek my costs of the action. There's a costs schedule at page 648 in the bundle.
Yes.
It's only two or three, it's only really 2 pages long. The headline figure for the costs of the entire action are 262,271 dirham. That's just over £53,000 or 71,000 US dollars. Given that that includes advising the client when this claim came in, dealing with the amendment that there needed to be to the claimant's particulars of claim, preparing the defence, dealing with the CMC, preparing the evidence and the documents, my fees for this hearing, I think running this entire case for just over £53,000 is remarkably reasonable compared to the costs that are usually incurred by parties in this court and in my submission, the figure is eminently reasonable, and Your Honour should just order it.
Mr. Dinesh, have you had a chance to look at this?
I saw, by my humble request, of course, the claimant, as from the facts, of course, I can't say anything about the facts now, a reasonable prospect which we believed, and for that purpose we tried to contest this matter, and we have also produced a court statement. So given the circumstances, my respectful submission would be to make it very reasonable, because this is very high, very, very high, and the amount involved is also, of course, amount involved is also very less, but we were fighting on certain principles, not on the quantum per se, but still, my respectful submission is, when looking at our cost, mainly come to very minimal cost. That is what my respectful submission is.
Well, I assume that your costs relate simply to this hearing.
Yes.
Yes, because you would have put your costs in on the basis that you succeeded, so to speak, and therefore everything else for the trial was still up for grabs. So that your cost figure is not comparable to the figure that's being put forward for the whole of the action. So, have you got any detail? Have you got any detailed submissions you want to make on the schedule that's been produced by the defendant?
Yes. I would like to kindly give me an opportunity so that can be deferred, because I already suffered, and I
want you to do it now, Mr. Dinesh. We're not talking about very big figures in the overall scheme.
No, it's not.
And I would propose, as the schedule was served 24 hours in advance, I would propose to deal with it summarily here and now. So if you've got anything you want to say, now is your opportunity.
I'm also in a different jurisdiction, and I don't know what is exactly the cost. I need to take instruction. I'm joining from New Delhi, so I don't know the cost involved.
Right. Okay, it's the end of your working day, no doubt, then. Well, let me just have a look at it, and I'll take a view myself.
My only respectful submission is the second shock should not be, may not be that big.
Can you tell me, Mr. Watson, what the hourly rate of Ms. Jabala is in either dollars or pounds?
I can in 2 seconds, Your Honour, the advantage of...
divide by 3.67 and tell me what the answer is.
In US dollars, her rate is, and I would note her rate is only 558.
Right.
US. I mean, her rate is only 50 dirham more than the equivalent fee earner on the other side.
Yeah.
Don't say that her rate is unreasonable.
No.
And the hours that the partner has spent, Mr. Balla has spent, are again incredibly limited. About 4 hours over the life of these proceedings.
Yes, it's mostly Mr. Brooks, isn't it?
It is.
It's Mr. Brooks and your humble fees.
Quite, Your Honour.
Yes. All right. Well, I'm going to make a summary assessment, and I'm going to assess an all-in figure, not on the basis of any scientific assessment, but simply on the basis that you never get quite what you ask for, and it'll be 250,000 dirhams.
I'm grateful, Your Honour.
All right.
I'm
And
grateful for the patient hearing given to me.
not at all, Mr. Dinesh. Thank you for your submissions. I'll put something in writing, and you'll get the reasons in due course. But thank you both very much.
I'm grateful.
If you would like to leave, then I can